city in a Batmobile. Even though it get crazy, niggas don't talk like Swayze.
What up? This is Swayze, and you already know I still don't got my silver play button, but I'm gonna make this a quick intro because I want you guys to hear exactly what Kay Flock's lawyer is talking about. Now, to summarize it up for all of you people that's not gonna listen to the whole audio, basically, them people over there on Reddit doing too much. Yes, I told you about these people last year, some of them at day room, and apparently they're sending threats to the judge, which is preventing Kay Flock's lawyer from moving forward with the case. They saying things like, yo, if y'all was real Kay Flock fans, y'all would have boomed the judge. If y'all was real K-Roy fans, y'all would have boomed the witnesses and all types of nonsense. And they're even sending direct threats through email to the judge. And mind you, the judge is like 70 years old. The judge's supposed to be retiring by the end of this year. This is not going to even be the same judge that's going to be on Kay Flock's case because they're starting trial next year. So the threats that she's receiving, even though they're just from some day room niggas from Reddit and shouldn't be taken serious, is the reason why this case is being prolonged. But that's only half of it. So I'm going to shut up and let you guys listen to what this guy has to say. And I'll see you guys in the next video. Reddit niggas doing too much.
Jeffrey Lichtman for Beyond the Legal Limit. I'm back, and we're here to talk about the Kay Flock case. Real name, Kevin Perez, my client, charged with murder stemming from an incident in December of 2021 in Harlem. Now, this case is pretty straightforward, although it was told two different ways up until a video of the incident was initially discovered. If you look at the press reports when this murder took place, Kevin, that's what I call him, was alleged to be walking by a barber shop in Harlem. And as he walked by the door, this is what the press reports actually say, he opened up the door, walked inside, and asked the victim, who was waiting for a haircut in the chair, what was he looking at? And then he shot the victim when the victim stepped outside to confront him. Now, initially, this shooting was described by law enforcement to be, in the media, to be gang-related. Now, again, once the video, because of course every inch of every street in New York City is covered by someone's security camera. Once the video of the incident was discovered, it was revealed that Kevin walked by the barber shop and the victim, who was standing at the door, not getting a haircut, not in a chair, but peering out, looking out the door, looking for something, it would appear. Well, he rushed out to yell at Kevin when he recognized him. That's what it appeared. I mean, you see it with your own eyes. Kevin waved them off and kept walking with a young woman friend who was with him. Just walked by and was like, nah, not interested. Then the victim, I hate to call him the victim because he was the aggressor. He then walked aggressively towards Kevin and the young woman with his hands in his pockets. He had one of those puffy jackets with pockets. And he was continuing to threaten them on the street, threatening them. Kevin is alleged at that point to have pulled out a gun and shot the victim twice. When the victim was placed on a stretcher, a loaded gun fell out of his pocket. So when his hand was in the pockets and he was rushing towards Kevin Perez, my client, Kay Flock, well, his hand was on a gun, a loaded gun, and confirming that the threats he was making were not empty threats, I would say. Now, both the victim and Kevin are alleged by the state to be in opposing gangs, and thus the reason that the incident even occurred. So this is supposedly gang violence, according to the police. Now, the police spoke to everyone in the barbershop that day, anyone who witnessed what occurred before and after the shooting. It was in broad daylight. There are videos that were had, statements of the witnesses. The entirety of the investigation was turned over to the defense, as the state is required to by law. But they didn't turn over the names of the witnesses of the people they spoke to. And the state's position is that the defendant and people, I suppose, associated with him are so dangerous that we, the defense, should not be permitted to have these names, as they may put the witnesses in danger, which is interesting because many of these witnesses are presumably gang members themselves, as was the victim, who had a rap sheet a mile long with horrible violence in it. So you can understand that I'm a bit dubious that it can be believed that these witnesses are in any kind of danger. But their position, presumably, the state, is that, this is gang violence, and gangs do all sorts of bad things to people that are witnesses against somebody in the gang. I get it. Now, it's obviously important that we have a chance to interview these witnesses because they may have seen or heard what occurred when the actual shooting went down. And what was said or done can make the difference between what's ultimately determined to be a murder or a case of self-defense. And the state will have all of these witnesses, or at least some of them, testifying for them in their case, meeting with them. They're all things that we can't do. We don't even know their names. And as you can imagine, this makes me uncomfortable because the witnesses who were with the dead gang member victim at the time of the shooting, presumably they're aligned with him. They're his friends. They're either in the same gang, as I said, or his friends. So common sense tells you that they're not going to be looking to do my client any favors in describing what occurred that fateful day, especially if you'll recall what first was told to the police, who then spoke to the Daily News, and it's online. They wrote an article about the shooting, and the article came out a week after the shooting, and it contained false information in it. False information that made Kevin Perez, K. Flock, seem like a premeditated killer. In the article, as I said earlier, law enforcement sources claim that Kevin walked into the barbershop, confronted the victim. It never happened. The tape is clear. He never went into the barbershop, never said a word to the victim. The complete opposite occurred, as again made clear by security camera video, which revealed a highly aggressive victim with a loaded gun in his pocket, with his hand presumably on the loaded gun as he's rushing out of the barbershop and confronting my client and his lady friend. So you can imagine why it's crucial for me, the defense lawyer, to get my hands on the names of the witnesses so that we can determine through our own investigation whether or not the witnesses have any bias against our client or for the victim. Now, their basis for refusing to turn over the names is, as I said, danger to the witnesses. But the law is pretty clear on this. There's a middle ground, a compromise that exists. Me, the defense attorney, can agree to not turn over the names of the witnesses to my client, to do the investigation myself with just my office and an investigator. And in this way, there can be no real claim that my client will get his hands on the names of the witnesses and do anything to intimidate or harm them, which of course is a joke as it is, because he's never even been accused of obstruction of justice or even approaching a witness in this case, let alone harming or threatening them. There's no accusation. There never has been. He hasn't done a thing like that. He's been a good boy since he's been arrested. He turned himself in. He wasn't even caught. He turned himself in. So we're told that the motion for this protective order to prevent us from getting that part of the discovery is going to be made months ago. This has been going on for 6 months. But the prosecutor was delayed in filing it, and I wasn't pushing hard for it at the time at the beginning because we had plenty of work to do on the case. And I don't think there was any gamesmanship by the prosecutor. He's a young prosecutor, not that young. He's a completely good dude, completely honest, I thought. I still think. I don't want to say thought past tense. He's a solid guy. He's been very easy to work with. But there's a limit to how long we can wait for this motion because we've got to get going. We've got to start talking to these people if we can. I need the names. And finally, just as the prosecutor is about to make the motion for the protective order, which will enable us to respond to the motion, which will enable a judge to make a ruling on the motion, which will hopefully enable me to get my hands on the witnesses' names. The prosecutor knew about the threat or was in any way connected to the threat. Of course he wasn't aware of it. He's in jail. He doesn't have Reddit in jail. But the prosecutor then noted, but I thought that I should at least bring it to the court's attention. And he provided a link to the Reddit post with the threat. So I'm concerned at this point when I read this email. Yes, K. Flock is not involved at all in the threat to kill the judge. So what? I mean, if someone around him wants to kill the judge and K. Flock is not aware of it, isn't that precisely the reason why the government would not want to give us the names of the witnesses in the case? Maybe someone around him would want to kill a witness. After all, they're willing to openly, publicly discuss killing the judge, apparently. So the threat directly impacts on this motion for the protective order that hasn't been made yet. And my thought was, well, why hasn't the government investigated the threat? I sent a letter back to the court noting that this was a threat to kill the judge. Where is the investigation? The prosecutor then wrote back and said he's not planning on doing an investigation. Why? Judges get killed in America. They do. It happens. How do we know it's not a real threat? And if the judge is threatened publicly but doesn't know about it until the prosecutor brought it up, maybe now this is impacting her feelings about my client. Maybe she shouldn't be the judge in the case because she's prejudiced by it. I don't know. I didn't know. I didn't have a chance to speak to her. when this email was initially sent by the prosecutor. But there's a potential motion to be made to ask the judge to recuse herself due to the threat that was reported against her. Maybe she thinks she can't be fair now. I don't know. She didn't write back to us and tell us a thing. I can't just ignore what the prosecutor revealed to the judge. I just couldn't, the threat. The basis for disqualifying a judge is a determination, in this instance, of whether the judge has an inappropriate awareness of an extrajudicial source, something that's beyond the evidence that she'd be seeing during the case, thereby resulting in an opinion on the merits on some basis other than what the judge learned from her participation in the case. That's the law. But here's the rub. This is interesting. Who decides for the judge whether or not she's to recuse herself, to be disqualified? Well, the simple answer is the judge herself does. And the law is clear. The decision is between the judge and her conscience. But even if she feels that she can still be fair, the law also makes clear that judges should avoid even the appearance of impropriety. So I wrote back to the judge saying, look, you haven't opined on any of this yet, but I want to talk about it. And we went to court last Thursday, and I wasn't there to make a motion to recuse, to disqualify her. I just wanted to hear what you had to say regarding the threat. How do we not at least hear her out? If I didn't ask her thoughts, I might never know if she was freaked out about the threat and needed to be disqualified. And I noted that the issue that arises from an email like the prosecutor sent regarding the threat to kill the judge is not limited to what the defendant knew or what he was connected to. I mean, that's part of it. But the more important part is the threat real? Is it credible? Who's the person who made the threat? And how does the prosecutor know that the defendant wasn't connected to the threat? He's just assuming. Has he done any investigation? I asked. Did you do any investigation? Oh, nothing, and I don't plan on doing it. No steps to investigate the comment. Again, my comment to the court on Thursday is, why not? The defendant's charged with murder, and the people, the state, have previously told us that they plan on making a motion for a protective order to prevent not only the defendant from getting the names of the witnesses, but they don't even want the lawyers, me, to get our hands on the witnesses. He's that dangerous, K. Flock, according to the state. That's what they're saying. Yet a threat exists online against the court in the name of K. Flock, and no investigation was done at all? I'm dubious, is what I'm saying. And just because the defendant, and again, in the mind of the prosecutor, on a hunch, without any investigation done at all, determined that Kevin was not connected to the threat, how do they know the threat isn't real? A threat like that, to kill a judge, regardless of whether the defendant was aware, surely is something to be investigated in a time period in our country where judges get killed. So if a decision, and apparently has been made, not to even investigate the threat, as it's not deemed credible for no reason at all, what was the purpose of even bringing it to the court's attention if it's not a real threat? That was what I asked on Thursday. If you don't think it's real, why are you even telling us, except to inflame the passions of the court? I mean, why did it need to be passed at all? No one knew about it. Nobody read it. At least the defense lawyers and the judge doesn't. The prosecutor apparently does. And I explained that it was clear to me that the only aim of passing along this threat to kill the judge, which was apparently spontaneously deemed to be a non-threat, it's to prejudice the court at a time when a motion for a protective order regarding discovery, regarding the names of the witnesses, and a very important motion that, if granted, will make it nearly impossible for the defense to conduct any kind of meaningful investigation of the state's witnesses, that email that was sent with the threat to the judge, they sent it right at the time this motion is about to be filed. And the criteria for granting a motion for the protective order to prevent us from getting the names of the witnesses is obviously the concern for the safety of the witnesses. Also, what happened is that when this motion was initially brought up in March, when it was first discussed in front of the court, I indicated it to the judge, and it hadn't been filed yet, but it was at least previewed. I indicated, look, I'm not going to fight this to the death. I'm willing to take a middle ground. I don't need the defendant to get the names of the witnesses. I just need them for my own investigation. And the law is clear. That isn't acceptable at times unless the danger is so severe. That's an acceptable middle ground. That's often the ways a motion for a full protective order that nobody on the defense side can get the names of witnesses. That's often how the issue is resolved. And the court reacted positively to my concession. And although it certainly wasn't binding, her agreeing with me and nodding her head, because the motion hadn't even been filed yet. But now we have this extrajudicial threat to the court, which neither the court nor the defense was even aware of, and the people claimed without any investigation at all is unfounded. I don't see how. It was dropped into the court's lap just when the motion for the protective order is about to be filed. I'm not sure what the purpose of doing such a thing was for, except to harm the defense's chances on that motion. And I don't mean to be repetitive, but these are issues repetitively. My point is that if the prosecutor doesn't think that the threat was even remotely credible based on no evidence, no investigation, why tell the judge? I mean, I guess in case she's walking down Reddit Street and she needs to have eyes behind her back? Why does she need to know about something that's not even real, according to the state? Now, of course, the irony of all of this is the judge is 70 years old and she's forced to retire by law by the end of this year. She is not going to be the trial judge regardless, because the case will not be tried by the end of this year. But she is the one that's making the decision on the government's motion for the protective order, and that's a hugely important issue. Now, one of the reasons that I wanted to appear before the judge, and as I said, I never made a motion to recuse her response that she's been threatened before, she'll be threatened again, she's not concerned. I believe her. I don't think for a second that she's going to be prejudiced by it. She assured us on Thursday that the Reddit threat would have no impact on her decision regarding the protective order request that the government would be making. But at least there's finally a date for the motion to be filed, and we expect a decision by early November, less than 2 months before the case is to be reassigned to another judge because of our judge's retirement, Judge Jackson. Case right now, and there's a little bit of gamesmanship in my mind, what was done by the government, and I don't know. I don't think I engage in gamesmanship as a defense lawyer. Some people may disagree. That's where we are. The case is going to start to heat up once that decision is made on the protective motion, and it's full steam ahead to trial. I don't see Kevin being convicted of any murder because I think he would be dead right now if he didn't use self-defense. He and his friend, his lady friend, would both be dead, in my mind, clearly, with a maniac who's rushing at them with a loaded gun with a bullet in the chamber and his hand on a gun approaching my client and his girlfriend. I mean, what would you do? You'd do the same thing.